to winning isn't easy. We're going to talk about the steps 4, 5, and 6 of the claims process, the claims evaluation process used by disability carriers or plans in a PD claim. Step 4, is there a causal relationship between the Parkinson's diagnosis and the assigned restrictions and limitations and your inability to do your own or any occupation? Now, this may sound stupid, but this is how the disability carriers or plans think. Look, the NFL is full of football players that have herniated discs in their neck or their back, and they're still all playing football. So who cares that you've got a diagnosis of a herniated disc? Or in this case, who cares you have a diagnosis of Parkinson's disease? Because you have the burden to prove that there's a causal relationship between your PD diagnosis and the assigned restrictions and limitations and your inability to do your own or any other occupation. In other words, you might have PD, you might have restrictions and limitations, but those restrictions and limitations do not preclude you from an inability to do your own or any occupation. So we've got to tie all of this together. The residual functional capacity form that I use in my Social Security PD cases, I think asks the right questions regarding these issues. The carrier's APS form, attending physician statement form, doesn't ask the right questions on purpose because they don't want to know the right answer, because if they know the right answer, they might have to pay your benefits. So I always ask my clients to give the doctor both the APS form and the Social Security residual functional capacity form, because I want to make sure it's accurate and complete. And I want you to be giving your doctor a history of your symptoms and functionality so that they can address the restrictions and limitations. Now, what the carrier is going to do is have their medical unit, their liar for hire doctors, review the file and the APS forms to determine your real restrictions and limitations. They don't have to accept what your physicians had to say, and they will have a hired medical gun say there's no objective basis for the restrictions and limitations. Once they've done that, they're setting themselves up for the next stage of a carrier denial. They're going to send the file to their internal liar for hire vocational evaluator. They're going to try to determine what your occupation was at the time you became disabled, the physical duties or cognitive duties of your occupation, and whether or not you can perform those occupational duties based on the restrictions and limitations. Again, you've got to show that causal relationship between the diagnosis and the restrictions and your inability to do your own or any occupation. So in this analysis, what's also crucial is what's your occupation? Your policy may provide that the carrier gets to determine your occupation based on an outdated book called the Dictionary of Occupational Titles. The definition may not be how you perform your occupational duties for your employer in the local economy. So you got to understand what the definition of occupation is that's being used, because you're going to back into that in terms of your description to your doctor about your occupational duties and your symptoms. But I also want to let you know that disability carriers often misclassify a person's occupation. So you need to be prepared for that. They may say that your duties don't involve, well, let's say, they may say that your job is sedentary in nature when in fact your job requires you to travel. So they will cherry pick the description of the occupation to either misclassify it or basically say it's a completely different occupation than the occupation you were performing. Now, you also need to understand that the definition of occupation is going to potentially change. And what do I mean by that? The definition of disability is going to change from an inability to do your own occupation, normally it's for 2 years, to a definition of an inability to perform any occupation by virtue of your education, training, and experience. Many disability carriers actually have definitions of the term any occupation. So you need to get that definition out. You got to be familiar with both because, again, when the definition of disability changes from an inability to do your own occupation to any occupation, the carrier is going to reevaluate your whole claim. They're going to look at your diagnosis, your restrictions and limitations, whether or not there's this causal relationship between your inability to do your restrictions and limitations and an inability to do any occupation. And if they can plug you into a sedentary work capacity, that's going to mean a claims denial. Now, this is not a real world test, and often the carrier is going to determine that you can do sedentary work just to deny your benefits. Yes, just to deny your benefits. Step 5. What do you say about your activities of daily living form and on your form? And is that consistent with your medical records or what you tell the adjuster during a call? Carriers are in the business of collecting premium dollars and not paying you benefits. They're going to look at what you put on that activity of daily living form, the ADL form, and they're going to compare that with what's in your medical records. And don't be surprised if you get a not so friendly call on a regular basis from the carrier checking up, and they may even put surveillance on you. So if you're getting calls that are beginning to be annoying and harassing, if they want to take your statement or you suspect surveillance, it's time for you to call an experienced disability attorney because you're getting set up for a claims denial. How about step 6? Step 6, does the policy limit how long the carrier has to pay benefits? Now, this can be problematic because there are some policies that say, look, we will only pay you benefits for 2 years. And if your medical condition is based on a subjective medical condition, we're not legally obligated to pay any more benefits than 2 years. And sometimes that subjective condition limitation is so broadly drawn that it may have language that says that a medical condition that's characterized by pain or stiffness is limited to just 2 years. Or they may actually even list PD as one of the conditions in which benefits are limited to just 2 years. And that's crap, but that's what the policy says. Additionally, there might be a mental nervous policy limitation that says, look, if your disability is caused or contributed to ever so small, my version of the Monty Python wafer thin mint, then you have a situation where your benefits are only going to be limited to 2 years if you've got that contributed to cause. It's not uncommon for people who have PD to be depressed or anxious or to have other psychological issues. And if your disability is contributed to just so slightly by any of those conditions, your benefits are limited to just 2 years. So the disability carrier is going to use that policy limit in their toolbox of claims denial tools and their analysis to say, okay, well, maybe we'll pay benefits, but we're going to deny this claim in 2 years because of the subjective medical condition clause or the mental limitation clause. And sometimes they're even bold enough to tell you that. Got it? Let's take a break.
Are you a professional with questions about your individual disability policy? You need the Disability Insurance Claim Survival Guide for Professionals. This book gives you a comprehensive understanding of your disability policy with tips and to-dos regarding your disability application that will assist you in submitting a winning disability application. This is one you won't want to miss. For the next 24 hours, we are giving away free copies of the Disability Insurance Claim Survival Guide for Professionals. Order yours today at disabilityclaimsforprofessionals.com.